On Thursday, March 14th, 2019, there was testimony given in the House of Representatives of Texas before the Committee for Public Education. The school district attorney, Holly Wardell, testified and vilified parents' attorneys, and in particular, attorneys that have come from New York to Austin in order to represent parents on behalf of their children with disabilities, because representing parents in special education proceedings is so, her word, lucrative. My name is Andrew Cuddy. I am the New York attorney that opened an office in Austin with the sole purpose of representing parents of students with disabilities against their school districts when their children are being deprived of a free and appropriate public education that they are entitled to under the Individuals with Disabilities Education Act. However, Ms. Wardell misrepresented to the committee that any New York attorney moved to Texas. In fact, Austin was just the third of our offices, and we hired attorneys in Texas to work in that office. Although I did get admitted to Texas and have a caseload in Texas, I do not live there, and I live in New York. The Cuddy Law Firm, I believe, is the largest parent special education law firm in the country. We have offices in New York, Texas, Ohio, Pennsylvania, and North Carolina. Our Austin office is led by Elizabeth Angelo. Elizabeth is a born and bred Texan, originally from El Paso. She is a former teacher and school district administrator, a mother of 3 special education children, and a foster parent to another. She witnessed years of systemic problems in the school districts, in the special education programming, and when she went to law school so that she could come back and try to address these egregious situations, as districts themselves were not open to the necessary systemic change. The 2 associates in our Austin office are graduates of UT Austin and Baylor Law School, so homegrown Texas attorneys, not carpetbaggers as Ms. Wardell would have you believe. Interestingly, Ms. Wardell spoke on behalf of the school districts and the financial and economic impact that an extension to the statute of limitations would have on districts. She did not address at all the impact it would have on families, and in particular students with disabilities, who become saddled with the cost of private services or perhaps lifelong support that has to be provided to their children because they were not provided appropriate services. She addressed the cost of this litigation for school districts. The primary cost to school districts for this litigation is the school district attorneys. They have their hands in the deep pocket, while parents' attorneys must often be working on a contingent basis and must prevail in the litigation in order to get paid. School district attorneys always get paid. Parents' attorneys sometimes get paid. And one more important point. Roughly 90% of the cases handled by the Cuddy Law Firm in special education matters involve parents that are on public assistance. These families' special education rights are frequently trampled on by school districts. The practice of special education law is not a lucrative practice, as Ms. Wardell alleges. Parents do not have the deep pockets. And if it were lucrative, ask yourself why there are so few lawyers doing it across the state of Texas. There's roughly a dozen, and why none of the white shoe law firms are making this an element of their practice. Now, briefly, let me discuss why this litigation can be so costly in Texas. I'll be direct. Many school districts' lawyers run up the cost of these hearings through their own vexatious discovery demands, delaying the hearings, intimidation tactics of the parents, and in their attempts to drive parents' attorneys away from this area of practice. Let's address Ms. Wardell's conduct specifically. Here is a finding from a hearing officer. The hearing officer finds that the conduct of Ms. Wardell was a violation of Rule 3.02, Rule 3.03, and Rule 3.04 of the Texas Disciplinary Rules of Professional Conduct. Rule 3.02, minimizing the burdens and delays of litigation, states that In the course of litigation, a lawyer shall not take a position that unreasonably increases the cost and other burdens of the case or that unreasonably delays resolution of the matter. Rule 3.03, candor towards the tribunal, states that a lawyer shall not knowingly make a false statement of material fact or law to the tribunal. Rule 3.04, fairness in adjudicatory proceedings, states that a lawyer shall not engage in conduct intended to disrupt the proceedings. But this is not all. During the same proceeding in which she was sanctioned by the hearing officer, Ms. Wardell had an ex parte communication with the Texas Educational Agency seeking to have retaliatory steps taken against the hearing officer. And what then happened to the hearing officer? She is no longer a hearing officer. Ask yourself why a school district attorney feels comfortable calling the TEA to have a hearing officer removed. This is an example of the type of lawyer frequently representing school districts in Texas. In contrast, parents' lawyers either are charging a client with limited resources for the representation, or they are taking on the risk of prevailing in order to be entitled to fees, or a hybrid of these arrangements. We do not have our hands in a deep pocket and do our damnedest to work efficiently because of this. As the practice of law goes, special education law is not particularly lucrative, as Ms. Wardell would have you believe. But then we've seen her lack of candor in other forms. Ms. Wardell also suggests that there is a traveling band of experts testifying in our cases. This is simply not true. In fact, parents are unable to recover expert witness fees in IDEA cases. This is an expense the parent must bear entirely, and there is no traveling band. There may be a few experts who repeatedly assist families in these desperate situations, but that is an issue of their own compassion and nothing nefarious, as Ms. Wardell would have you believe. Ms. Wardell further suggests that the attorneys for parents do not pursue the parent's desired outcome, but whatever they can make stick, is the way she said it. This is absurd. What parent would engage an attorney like that? Not one. Ms. Wardell then posited that the IDEA has a squishy legal standard. There's nothing squishy about the legal standard. Many school districts comply with the law and provide appropriately for students. Those that don't find an excuse for their lack of professionalism. Squishy is an excuse. Let me end by highlighting why the Cuddy Law Firm opened an office in Texas, in its capital. The state of Texas has long underserved students with disabilities. Our firm travels to the sound of the guns, and a battle is waging in Texas. The Texas Education Agency and its subsidiary school districts have long tilted the field to their advantage. They established an 8.5 cap on classification rates, effectively denying hundreds of thousands of children of their right to an appropriate education. TEA seems to work hand in hand with school district attorneys to ensure that hearing officers who rule favorably for parents cease to be hearing officers. I do not believe this trend is a coincidence. Many of the parents who contact our office are dealing with egregious situations. A staff person splitting the child's face open with a trash can top. A child physically restrained by multiple adults on top of him, nearly killing him, but fortunately, only breaking his sternum. The districts routinely failing to identify children with dyslexia and passing them along from grade to grade. Students with autism, left home without programs or with seriously deficient programs, regressing. Students referred for criminal prosecution rather than having their special education needs met. I could go on. One last word for Miss Wardell. The Cuddy Law Firm is here to stay, and not because Texas is a lucrative market for our area of practice, but because there are people of your ilk fighting on the other side of the table, and we intend to be there for these parents. And we want other attorneys to join the fight on behalf of parents of students with disabilities. If you are a Texas attorney hoping to assist in these battles, please contact me and I will send you a discount code for 9 CLE credits in special education law, offered at www.sealhouse.us. There are training videos also there for advocates and parents and students. If you email me the reference to this video, I will shoot any parent or lay advocate a discount code as well. Student videos are free. These 9 hours will get a lawyer started in special education law, so you too can have the pleasure of opposing Ms. Wardell and attorneys of this nature in due process hearings and securing the rights of students with disabilities. Perhaps there are folks out there who would like to discuss these issues directly with me or with Ms. Wardell. Again, my name is Andrew Cuddy. My phone number is 315-370-4020. My email address is acuddy@cuddylawfirm.com. Miss Wardell's phone number is 512-476-9944, hwardell@edlaw.com. Feel free to call us.